For any dispute or disagreement between parties, there exists a dispute resolution clause in every contract normally. It tells how disputes arising out of that contract would be adjudicated on. It can be done by good faith negotiations between the parties, which can get escalated to mediation, and finally, it can end in arbitration or even before courts of law. So, what is arbitration? Arbitration is a private alternative to going to any court that you have heard of. It can resolve disputes. It is a formal process in which the parties agree to submit their dispute to an arbitrator or a panel of arbitrators instead of a judge. But why do parties prefer arbitration? Number one is the speed. If you go through the court procedures, it would take much more time. For context, go to the National Judicial Grid. There are more than 1 crore civil suits pending in the country right now. The cost is another factor. Some senior counsels can charge up to 15 lakh rupees per appearance in the higher courts, and that can be even when the matter is not even called out. Over multiple hearings across years, paying court fees and incurring all kinds of charges, the price for resolving that dispute increases. Number 3 is the benefit of privacy and confidentiality. Now, imagine you are a company. If there is some dispute which can cause reputational damage, even from mere hearings, the company would want to avoid those hearings because it can affect the company's perception in the market, it can affect stock prices, and the company thus wants to keep things private. Number 4 is procedural flexibility. Now, arbitration does not necessarily have to follow the Evidence Act or the Civil Procedure Code. Of course, some principles of natural justice apply, but there is nothing strict to be followed in terms of procedure. And number 5, the grounds of appeal for any arbitral award are very limited, and that will be further dealt with during the course.